Get ready for the dictation. Dictation will start in 5 seconds. Start. Pursuant to this FIR, a case was registered for offences under sections 363, 376, 302 and 201 read with section 34 of the Indian Penal Code. The investigating officer PW13 went to the house of the respondent. He found that the floor of the house had been freshly covered with cow dung. He found some traces of blood on the wall of the house. He also found a piece of newspaper and a quilt which were stained with blood. These items were seized by the investigating officer in the presence of punches. On the same day, the respondent and his mother was arrested and put up for trial. It is the case of the prosecution that a grinding stone which had blood stains on it was recovered at the instance of the respondent from a field of grass close to this house. It is also the case of prosecution that a full pant and an underpant belonging to the respondent and an underwear belonging to the little child were recovered at the instance of the respondent from the sugarcane field where they had been worried by him. It is held that the fact of a child witness would require the court to scrutinize the evidence with care and caution. It is held that if the evidence is shown to have stood the test of cross-examination and there is no infirmity in the evidence, then a conviction can be based upon such testimony alone. It is held that collaboration of the testimony of a child witness is not a rule but a measure of caution and prudence. It is held that some discrepancies in the statement of a child witness cannot be made the basis for discarding the testimony. It is held that discrepancies in the deposition, if not in material particulars, would lend credence to the testimony of a child witness. It is held that while appreciating the evidence of the child witness, the courts are required to rule out the possibility of the child being tutored. The learned trial judge has put preliminary cautions to each of the witnesses and satisfying himself that they were answering questions intelligently without any fear whatsoever proceeded to record the evidence. In the chief cross-examination, each of the witnesses has given all the details of the occurrence. There has been a searching cross-examination and the witnesses withstood the same. We have also gone through the evidence and we do not see any reason to doubt their evidence. They are the most natural witnesses who had been present in the house at the night time. Both the courts have accepted their evidence and we see no ground to interfere. There are no merits in this appeal and the same is dismissed. There is nothing in Section 27 of the Evidence Act which renders the statement of the accused inadmissible if recovery of the articles was made from any place which is open or accessible to others. It is a fallacious notion that when recovery of any incriminating article was made from a place which is open or accessible to others, it would vitiate the evidence. Under Section 27 of the Evidence Act, any object can be concealed in places which are open or accessible to others. The person who hides it alone knows where it is until he discloses that fact to any other person. Hence, the crucial question is not whether the place was accessible to others or not, but whether it was ordinarily visible to others. If it is not, then it is immaterial that the concealed place is accessible to others. Full stop.